Welcome back to Raymond and Raymond Legal Insights. Today we are going to look at the Electronic Communication and Transaction Act, given the increase in online transacting since the lockdown. Businesses, corporates, and governments had to look at alternatives for business continuity. I will refer to the Electronic Communication and Transaction Act as the ECT Act going forward. The Electronic Communications and Transaction Act of 2002 is a core piece of legislation regulating e-commerce in South Africa. The Consumer Protection Act of 2008 and the Protection of Personal Information Act of 2013 also play a key role in governing e-commerce. The internet has changed the way business is done today. Internet commerce has become a very important part to national and international business, with websites such as eBay and Takealot as typical examples of electronic or e-commerce platforms. With the current situation with COVID-19, we see more people taking to electronic forms of communication since the lockdown was announced. Companies had to look for alternatives for business continuity. Many consumers have also taken to online shopping since the lockdown as an alternative to going out and shopping for essentials. I want to look at the business landscape with e-commerce as a platform with specific reference to the global legal uncertainties and the ECT Act and how it deals with the validity of an agreement, that is, the offer and an acceptance. E-commerce consists of 4 basic stages in a transaction. Number 1, when you log on to a preferred supplier. Number 2, when you select a product or service and submit your details. Number 3, when you select on the payment information. And number 4, when you click on the button that says Purchase, and in addition to which you also agree to their terms and conditions. The ECT Act in Chapter 3, Section 11, Subsection 1, mentions that no data message shall be without legal force and effect, merely because it is in the form of a data message. This simply means that any offer and acceptance may be made by means of an electronic data message unless formalities are prescribed. This is further confirmed by Section 22, which stipulates that no agreement shall be invalid merely because it was concluded in part or wholly by way of data messages. The traditional analysis to establish whether a contract has been concluded involves classifying the response of the parties as an offer, acceptance, and counteroffer. According to this, a valid and binding contract is established by the offeree accepting unconditionally to the offer made by the offeror. For legal purposes, faxes, emails, SMSs, and interactions with internet websites must be regarded as indirect communication because there is not necessarily any direct interaction between the addressor and the addressee. Telephonic communications between parties are regarded as direct communications. However, voice communications are generally excluded from the application of the ECT Act by the definition of data message. Section 1 defines data message as data generated, sent, received, or stored by electronic means and includes voice, where the voice is used in an automated transaction and then stored as record. With direct communications outside the scope of the ECT Act, the general rule of contract applies, namely that the offer and acceptance are subject to the information theory. Unless there is a clear indication in the offer that the other party is entitled to use indirect means of communication, the other party is not authorized to use such forms of communication. The fact that a party uses a particular method of indirect communication for its offer will usually be regarded as applied authorization for the addressee to use the same method of communicating acceptance. Use of such forms of communication as fax or email is at the risk of the party using them in these circumstances. Again, the general rule that the information theory will apply to the information of the contract. Where both parties use data messages, that is, when they communicate by telephone, they are communicating directly, almost, as if they are in each other's presence. The parties will know immediately whether the acceptance has been received and if there is any break in communication, which will immediately be apparent. However, this is not true in the case of faxes, emails, and SMSs. While transmission is usually instantaneous, With these, any difficulties in transmission or receipt of the messages may be readily apparent. There is also no certainty that the other party will take subjective notice of the acceptance immediately. Ultimately, the notice depends on whether the other party actually reads the fax, email, or SMS. Again, as mentioned earlier, the ECT Act deals with fax, email, SMS, and interaction with websites as a form of indirect communication within the definition of data message. The ECT Act has placed the risk of electronic communication on the sending party by making use of the reception theory. In terms of this theory, a contract is formed at the time and place at which the offerer receives the acceptance. It is interesting to note that the offerer does not need to take subjective notice of the reception to make it effective. The reception of data messages cannot be manipulated by the receiving party as it can in information theory. For example, if an offer has been made and remains open for a certain period of time, the offer could delay acceptance by simply not opening the notification of acceptance until after the period runs out. In terms of Section 23 of the ECT Act, the data message is deemed to have been received by the addressee when the complete data message enters an information system designated or used for that purpose by the addressee and is capable of being retrieved and processed by the addressee. In addition, it is deemed to have been received at the place where that party has as usual place of business or residence. This means that when an acceptance is sent electronically by fax, email, or SMS, the contract will be deemed to have come into existence when the acceptance is received by the offeror. It is important that the offeror expressly stipulates the manner of acceptance. This should usually be done in the offer. The invitation to do business must be set out in the standard terms and conditions of the offer, along with the parties' clear intentions to do business. If there is no provision stipulating the manner of acceptance, the general rule will apply, and the contract will be deemed to have been concluded at the time and place in which the offerer receives the communication confirming acceptance. In part 2 of the next video on the ECT Act, we will look at contracts in the e-commerce form and electronic signatures. In the meantime, if you require any further assistance with the ECT Act and your contracts, please contact Raymond & Raymond Incorporated.